Well, a new report into the ACC has found the number of people having their claims denied could be as high as 300,000 a year. That would be more than triple the official figure. The lead author, Warren Forster, says the discrepancy is due to a lack of transparency at the ACC, which makes it difficult to identify, let alone fix, systemic problems. Mr. Forster says it's virtually impossible for ordinary people to understand the complex legal tests ACC uses to decide whether to fund treatment and compensation, and that those tests are being applied ever more narrowly. He's recommending a commissioner be put in place to establish a network of advocates to help people navigate not just ACC but other organisations which can provide compensation, such as WorkSafe, the Health and Disability Commissioner, and the criminal courts. Warren Forster, who, as we said, co-authored this Otago University document, is in the Dunedin studio. Warren, good morning.
Good morning, Catherine.
About a decade now, I think you have been delving into ACC from all sorts of perspectives, really. And have you seen some shifts, by the way?
We have seen some shifts, and that's part of the key problem, is that the performance improvement framework from the State Services Commissioner said, look, ACC swings like a pendulum, and we have those changes and shifts on the ground without actually any change in law. So what we're having is a number of non-transparent processes constrict and expand the scheme from time to time. We don't know what the actual effects of that are because we don't measure it. We don't know how many claims are declined because ACC won't tell us. And that's why we actually, to really get in to fix some of these personal injury problems, we need someone whose job it is to try and make that system work.
We had the major inquiry following another iteration, actually. It was your last work, I think, which was talking about that it was virtually impossible, should one appeal, to win an appeal against ACC, that it settled right at the last hurdle, right at the appeals court level. That's for the few people who stayed in the system that long. Now, from memory, that was a major factor in the launching of an inquiry done by Miriam Dean. What did the Miriam Dean inquiry find about how many people were being declined?
Well, Miriam Dean struggled, as we all have, to get information out of ACC. So in her report, she said ACC estimates that the total number of declines from cover and entitlements is around 70,000 a year. And that was much lower than we expected. We've tried to get the data out of ACC in a direct sense, and they don't have it. And that raises issues in and of itself, which is why we really need someone like a commissioner. But what we've since gone back and done is we've got the number of declined claims for cover, and we know what that is. It's around 50,000, slightly over 50,000 a year. And then we've gone and looked at what information do we have about entitlements. And as we've gone through that, we've been able to piece together the best picture that we can. And we found another 110,000 treatments that had declined. And in addition to that, we have weekly compensation and the other entitlements, vocational rehabilitation, social rehabilitation. So the actual number is much, much higher than the official figures.
I'm going to ask you just to pause and help me get my head around this for a moment. So there is an official figure for declining of cover. Have you extrapolated from that? Have you done some modelling to say, look, here's what does happen in normal circumstances, here are the ratios you would expect, and therefore that official number of declines needs to be extrapolated to other realities? How exactly did you come up with a figure 4 times the official?
So what we have is New Zealanders get injured and they go and see a GP or a physiotherapist or someone that lodge a claim for cover. Now there's about 1.9 million claims for cover made a year, and we know from ACC that around 50-something thousand of them are declined every year, claims for cover. So the other 1.85 million of people, they have cover, and then at that point ACC needs to decide what are you entitled to, what support will we give you. So from that other 1.85 million who don't get shut out to start off with, there's then a number of declines that happen across the life of their claims.
Right, so phase 1 is cover. A letter from ACC, you've been to your physio or you've been to your GP, they filled out a form, they've sent it off, ACC sent you a letter and said, we will cover. What's step 2?
Well, step 2 then requires, so the first one is a decision from ACC on cover, then ACC needs to decide what are you entitled to. Now that process is quite complex, and ACC's turned it into a system where you need to lodge a formal claim for cover for weekly compensation or treatment or so on. And that's not how the scheme started, but it's what we've got now. So at that point we have a claim for entitlement, and ACC needs to make a decision on that claim for entitlement. And what we're trying to get to is how many adverse decisions are made on entitlements across the board. that will give us the pool of people who have adverse decisions that need some sort of access to justice experience. Now, if you take out the 50,000 that get covered, that leaves from the official figure 20,000 more declines across the entire system, and that simply can't be right. So if we look at surgery, elective surgery alone in 2010, there were 17,000 declines just for surgery. We look at the other treatments. In 2012, there were 93,000 declines for other treatments. So package
You're
that
way
together.
over 20,000 already, aren't you? Okay,
You're-
keep going.
Before you even look at other entitlements, and then we look at weekly compensation. So we know that tens of thousands of people receive weekly compensation. Tens of thousands of people have weekly compensation stop. We don't know if those decisions are correct or not. We don't know when ACC gives people formal notice. We know that a very small number actually end up in the review process, and we don't know why. So we've estimated that another 20,000 compensation, so weekly compensation and lump sum compensation decisions are made. I suspect that's very conservative. We then have a number of rehabilitation. So everything else that ACC is meant to be doing, so home help, attendant care, vehicles, transport, all of those things. And there's a number of decisions in there, and we've estimated that at 30,000. But again, I think it's much, much higher than that. And then we have the informal decisions where someone rings ACC and says, can I have help with such and such? And they say no, and there's no formal decision given, and the person doesn't even know that they can challenge it. And there's probably a lot more in that group. But when we're well over 70,000, and the official estimates just simply, can't be correct.
Well, how are they reaching that? Are they only counting one particular aspect of their work? Is that what you're saying?
I've got no idea. I would love to know, because it's not 50,000 covered. It's not 70,000 covered claims that are declined. It's 50,000. So I don't know where they got the other 20,000 from, but it simply can't be right.
But you were saying 17,000 surgery declines alone. So there's the 20,000.
Before you go into anything else. And surgery is just one of about 50 entitlements you can get under the Act.
So surely in these days of fairly decent-sized computers, you would be able to keep pretty real-time track of exactly where everybody is in various categories, wouldn't you? Wouldn't you expect? Well,
you would, Catherine. If you go back to where the system began, Owen Woodhouse said at the beginning, this system needs to make the best possible use of the records that it's going to create because they're unique. Terry Eisen, a Canadian academic, came to Wellington in 1985 and he said, look, there's a new thing called computers. Let's use computers to see what happens to people so we can learn from it. And these same things have been reflected in Miriam Dean QC's report, where she says, look, it's staggering that we don't have data on this.
Apart from anything else, you can get the cost-benefit out of it, can't you? You can see how much was spent on someone and ultimately what the result was for them by all kinds of measures, including economic measures. Are you sure you haven't double-counted, by the way? There might have been some people being declined, or do you not care if you've double-counted if they've been declined for different kinds of aspects of their requests with ACC?
Look, ACC may have declined one person's claim 200,000 times. That's possible. But it's not really a matter for me. What I'm trying to do is to work out what is the pool of adverse decisions, and what I've found is that we don't know. And your point about gathering data so we can make decisions, we need data for policy decisions. If ACC's declined the same people 10 times, that's a massive access to justice problem. And the way that I've got the data and that I'm looking at in terms of cover is that that's cover declines. There's a whole nother process for lodging a surgery application. It's called an assessment report and treatment plan. There's a whole nother process for lodging a claim for other treatment. It's called an ACC 32. So we're not here talking...
And I know, and they would not give you figures on those. They could not give you figures on those specific requests, or did not.
Look, when we started this project, we tried to get data. Miriam Dean QC, when she was doing her review, tried to get data. She went to them and said, like, what's going on here? We conservatively estimated the number, but once we've found the actual figures, they're going to be much higher. And the key point is we need to have a way to make policy decisions based on data. At the moment, we're guessing. Okay. And that has to change. And it needs to be someone's job, not just looking at it within ACC, but looking at it in the entire system, how people work their way through the system, because otherwise, how can we fulfil our obligations to provide access to justice for people? And that's really the key point.
Let's look at the other big driver here, which has been the theme of some of your work over this decade, which is the toughening, by your argument, the narrowing and the toughening of the tests required to get treatment. And you talk about the causation tests, right? Now, we've been there before. We've talked about in the case of orthopaedics in particular, and we've had other doctors and physios talking to us about this as well. You go with an injury, you've injured yourself, and you're told, sorry, this is an age-related degeneration, you're not getting your treatment. That became a trend, and I think that was also part of what was the Miriam Dean investigation. What are you finding now about the causation test? Where do they sit in the decision-making process, and what are you finding about how they are being applied?
Great question. Our report analyses where the tests fit, and the tests go the whole way through. So when a person gets injured and you go to whatever treatment provider you go to, they apply what's wrong, I've got a sore knee, back, whatever. And then there's a process for lodging a claim for cover. There's a causation test there. It goes to ACC. Now, we don't know what happens when it goes to ACC, and certainly the data seems to be that ACC takes a different approach in different cases depending on what the cost and the risk of the claim is going to be. So if we just park that idea, ACC takes a different approach to different types of cover, and it seems to be based on the person and individual data, which is non-transparent and we don't know. So once a person gets cover, then ACC has to apply slightly different causation tests the whole way through the Act for each of the entitlements they get. And again, that test, although those tests and the group of tests about entitlements seem to be done differently for different people. Now, this is non-transparent, and we have to have a way to figure that out. Now, and the point is that in some cases, ACC seems to want more and be more sure than in other cases. And it seems to be that difference is based on what the potential cost of the claim will be over its life, and what the effect will be across the entire system. So some people get cover and then they have a fight later when they need entitlement. Some people don't even get entitlement or don't even get cover, so that the fight starts from the beginning. And then the person leaves ACC, and then we look at, let's say, a wider system. So there's a different system of causation in WorkSafe, and there's a different system of causation when the coroner looks at something. And what we're saying in here is we need to take a look at the entire system, and we need a data-driven policy development, and people who get injured need to be able to understand what actually it is they're going to get cover entitlements for. Now, what ACC says is we should re-educate New Zealanders to explain to them this complex system. And what we're saying is, well, actually, the system's meant to be there to serve us, and let's bring the system more into line with what people want. And we're not the first people to say that. The Performance Improvement Framework said it, the Minister said it previously, and what we really have to do is to find a way to make that entire system work more effectively, because at the moment it's not. And if you look at medical evidence, ACC in some cases uses their big machinery to obtain medical evidence. They say we need to be sure based on 2-3 expert reports. A person who's injured has almost no chance of getting one report, let alone 2 or 3 to challenge it. And that's, we have a application of a medical model. The Court of Appeal in Ambrose in 2008 said it's not a medical causation test, it's a legal one. And the problem is how does ACC staff understand and explain that? And what we've set out is, let's put a section in the Act that says when it comes to looking at causation, here's the stuff you need to remember, ACC. Hey people, when you're challenging ACC, here's the stuff you need to look at. And that's what we're saying. We're not saying we need to completely rewrite the boundaries of the scheme. We're saying let's be consistent about how sure we need to be. Let's take it away from a medical evidence battle, which is frankly unlikely to be resolved in the short term or mid-term even, and let's look at a different way of doing it that fits what New Zealanders expect of the system.
Well, what they pay for, by the way, through a levy. This actually is part of a legal argument. This is an entitlement. This is not, you pay your taxes and they get distributed however they get distributed. This is a levy that people pay for an entitlement, like an insurance premium. Okay.
That's correct. And if you ask ACC, we might have some good data on levies, but it's an argument for another day.
We'll talk more about the data at the moment, because this is a government that's quite interested in data. It's very interested in certain people's data, but anyway, we'll come back. Certain people, I'm referring, of course, to our recent stories about going to the NGOs and asking them to hand over information that they're reluctant to hand over. Let's come back, because I want to just define between two different things, particularly for someone who might be about to or is navigating the system. Previously, again, we've talked about the specialists and the preferred specialists. It has been implied, or perhaps shown in some instances, that there tend to be some specialists ACC uses a lot for its assessments, and that has been raised as an issue previously. So the specialists, opinion on a specific case is one thing, but just come back to that process we were talking about earlier. Are you saying that in some instances you go for your initial application, you go to your doctor or your physio with a prima facie case of an injury, and the injury gets some sort of a description by the physio or the doctor who sends off the form, and then later when a different or more substantial injury is identified, has the initial diagnosis or the initial assessment, if that's changed, because is that creating problems for people?
Huge problems. And
give me an example. Walk me through an example of it.
Sure. So what we're talking about here is a narrowing of what people understand to be covered. So I fall over and I hurt my knee skiing. I go to my doctor and I say, I've got a sore knee. I've got pain in my knee. I can't walk properly. The doctor lodges a claim for cover, and depending on what type of treatment provider it is, there's limited what they call read codes that ACC can use to do that. So most claims in New Zealand are lodged for a sprain or strain. So I don't know the data, but like I'll guess maybe 1 million claims or more are minor contusion, soft tissue injuries, and they're probably much more than that. At some later stage, a number of those will actually turn out to be a very serious injury, a tear of a ligament which needs surgery, a disc injury which needs surgery, or something else. There's no claim for cover made for that serious injury, and this is what I call the scope of cover argument, and we don't address it in detail in this report. It's one of the systemic problems the Commissioner will have to look at. But ACC then says, look, your need for surgery is due to your disc injury or your tear, not your sprain. You don't have cover for your sprain, and sometimes they
but
make
hang on
it
a minute.
explicit.
They didn't know what it was at stage one. They were looking, they were looking at the evidence when someone first appears without further investigation, including specialist investigation. So effectively, they're saying whatever has been described in the first instance is what you're stuck with, even when further medical investigation reveals it to be something else.
Well, Catherine, part of the problem is sometimes they do that, sometimes they don't.
I mean, it's the injury, it's the event. I mean, this is the thing. It's an incident, an accident that we're talking about here, and its precise consequences, the precise nature of the injury from the accident can be sorted later, surely.
Look, Catherine, and that leads to a lot of the dispute with people being heard and people being frustrated with the system. It undermines trust and confidence in ACC. So that's exactly the problem, is that the health system, for example, works on a discharge diagnosis. If I go to hospital with a sore back/stomach, I may have cancer, I may have a disc injury, I may have some other thing. There's no key performance indicator and measurement of the healthcare system based on the initial presentation, because it just doesn't make sense. ACC's analysis is based almost exclusively on the initial claim. And what we then have is a situation when you get down the track, as you do, where you identify the serious injury, the tear or so on. What do you do then? Do you need to lodge a new claim? Does a GP need to write and say, look, it's actually turned out to be a tear, please add it in?
That sounds quite logical to me.
Well,
because it's the medical investigation of the accident you had that has given more information.
But again, shouldn't it be a case when it turns out that you have a sprain and it turns into something more? Shouldn't ACC then go back and look at that itself? Shouldn't we? Do we need to have a whole nother process?
This is my point. You shouldn't. Yeah. You should have the same claim, getting better informed as it goes through the system.
And that's not how it works now. And that's one of the reasons we say that we need to change ACC. And what we need is an independent system that's not incentivised around exits, which is the whole way ACC's incentivised and managed now, and is actually incentivised and managed in a different framework. And we need to see change here. We need to stop fighting about medical evidence and look at something else.
Let's talk about those incentives, because this is something else you draw attention to. And I'm looking at just page 3 now. We say the growing issue with causation is a result of inappropriate incentives and performance indicators being placed on ACC and its staff. Does this come back to the way things are measured? What are those incentives? What are those performance indicators that risk having a perverse outcome? Because the staff are simply doing what they've been told to do.
Great question, Catherine. What are those measurements of the system? And again, if you could get that data out of ACC, that'd be great. So what we have is measurements of exit, so how long people are on the scheme for. That seems to be permeated the entire organisation. So they measure the number of days someone's on ACC for. And it's not transparent. We don't know how that works or what that works with, but we do know, for example, when the cull came in for the long-term claims, there was specific key performance indicators agreed to where they said the number of long-term claims will drop, and that then went out to the branches, and they were measured on net exits, and we have those documents.
Well,
and
that could be good news, couldn't it? If it meant that very intensive support and investment in rehabilitation and getting someone back to work has resulted in a shorter time on ACC, that would be seen as a win-win. But is that how it's measured, or is it simply numbers of people on a list?
Well, that's the whole point, Catherine. We don't know, and my suspicion is it's number of people on the list because we don't have outcome measures. We don't know how many decisions to decline are made on the basis that a person... So of the 100,000 that get weekly compensation, let's say 90,000, I'm plucking a number here, go back to work, and the reason for the exit is they actually return to their job. Great news, great outcome. The other 10,000 people may be exited because of they're vocationally independent, or the reason that you can't work isn't your sprain, it's your disc degeneration or your whatever. So again, we don't know that data, and there's no measurement, there's no way to check whether that's actually correct. And my suspicion is that there's quite a few people leaving the scheme who haven't had all of the rehabilitation they need and all the treatment they need, and the data that's coming out seems to support that.
The data, and this is one area actually where, as we said, given a great interest in data-driven information by this government across all areas in order to get the most cost-effective and best results, we are told, them to find efficacy and to put the money where the most efficacious stuff is happening. It seems extraordinary that this system is not being deeply built into what is happening with ACC clients. Not a new idea, you would say, either, the data-driven approach. It almost predates computers, in fact.
Look, it does, and what the performance improvement framework does is said there's been a swing backwards and forwards across the years. So, for example, in 2009, did the number of claims that were declined double? Who knows? But it may have. And if you go back to various changes that have occurred in the scheme, the number of reviews and the increasing number of reviews and disputes with ACC and challenges of ACC aren't tied to changes of law. They're tied to changes of policy.
Well, you make this point directly. In fact, the Commissioner, the Commissioner that you were saying, here we go. Independent reviews of ACC, including by the State Services Commission, have recently acknowledged the problem of ACC becoming a political football. And there's another part of this scheme. When that cull that you talked about happened, ACC was in its so-called financial crisis. It then came out of its so-called financial crisis and levies got cut. And the reason that happened is, of course, it has major, billions of dollars of international investments because it has to hold that liability. It has to have major investments in order to cover its liabilities. So its financial fortunes tend to swing with whatever's happening on the global markets. Again, is that part of the whole political football that you would draw attention to? And again, that has to be perhaps looked at, how we measure its own liquidity. This has been the subject of previous discussions as well. Look,
definitely, Catherine, and let me say ACC does a fantastic job for New Zealanders of managing its money. It is a world leader in this regard. Its returns are well above benchmarks in every single year that it's been in business. It's mind-boggling how good ACC is at that. Nonetheless, we're conflating here how well ACC manages New Zealanders' money, or its money, depending on your perspective, with the changes in liability. So, for example, ACC set out in 2009 to cut claims and reduce its long-term actuarial liability, I think by $2 billion or something to that effect. They more than doubled their success, so that they achieved a $4 billion actuarial release within the time frame that they set for themselves. So they did a great job of reducing their liability. At the same time, the global markets recovered, and now we have a scheme that's almost fully funded. But again, have we looked at the impact of that $4 billion reduction in liability on the people? What we've really done is cost shifted that cost back to society, which is the antithesis of the Woodhouse vision, and it's not the purpose of the Act. The purpose of the Act says we're going to reduce the cost of injury to society, but we're not doing that.
The idea of the Commissioner, you mentioned something else here, as well as, I guess, keeping the system honest. What would they do? How would they be able to handle all these individual cases, by the way? What do you view their actual role being? Or would they be asking for and assessing the sort of transparent accountability measures you're talking about?
Look, they'll be doing both. They've got a key role in oversight, and what we're suggesting is that we need to have system advocates, similar to the Health and Disability Commissioner, to come in and deal with individual cases, because they're a great source of system learning. I don't know how many hundreds or thousands of cases that I've looked at across an entire period of time, but you get a pretty good picture of how the system's operating from looking at bulk cases. And that should be done in a way that we have system learning, not just with ACC, but
with WorkSafe as well.
With WorkSafe and with the rest of the system. So we've got an investigation process into individual cases, and we've got an investigation process into the system, and that the Commissioner should deal with basically overseeing the entire system.
Will this need a new computer system? I mean, I'm not joking here. I mean, IRD at the moment are busy spending $1.5 billion on gradually bringing on board a new system, and for the kinds of analysis that you would like to see happening here, is there likely to be a need for an upfront investment?
Well, Catherine, I'd say probably, but until we know what ACC systems are using, that they use a fairly complicated system of data management. It appears that ACC has a lot of data about New Zealanders that isn't just related to their injury but other things, and that's all held on a particular database. ACC has, I think, 5 or 6 different systems. That needs to be transparent. We need to know what they do, and we need to work out, do we need a new one? And if we're looking at, I don't have all the answers here. What we're trying to say is let's build an institution that can answer these big questions, because I can't do it myself, and that's what we need.
On the WorkSafe question, are people unaware, you mentioned the Health and Disability Commissioner also, are people unaware of some of what they could be claiming in these other areas, by the way? We think of WorkSafe as the accident and injury investigator often, but what are the downstream entitlements that people might not even be aware of?
Great question. We've basically trying to redefine this and say, let's look at the entire system and see how that entire system is working. It could be that it's working perfectly, that a person who gets injured understands they lodge a claim for cover with ACC and get compensation. They then need to go and see that, make a complaint with whatever body it is that deals with the fault underlying their injury. So Workplace looks at fault, Health and Disability Commissioner can look at fault, and all these other things. And then if they want to get more compensation from a car accident, for example, then they need to ensure the police prosecute and seek top-up compensation through reparation at sentencing. But my intuition tells me that New Zealanders don't understand how this entire system is working. They don't even know how ACC is working. And from what the Chief Executive have said, it appears that some ACC staff themselves don't even understand the entire processes that are required. So it needs to be someone's job, when a person gets injured, to step in and say, look, here's how you navigate the system. And we're not talking about providing legal advice and representing them in a formal dispute. We're talking about helping them get through, much the same way as Health and Disability Commissioner advocates help people through that process. And what we're saying is we have to have an institution that does that. And we're also saying ACC can't run that institution, which is, we need system navigation, but really we need someone independent doing it, and we think a commissioner with a series of advocates is a really good way to do that.
Thank you very much. Really appreciate it. Warren Forster, he is the co-author of this report from the Otago University Faculty of Law Legal Issues Centre, the Law Foundation also involved in that project, and he has been working for a decade now on various inquiries into ACC.